Greetings, 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 greetings. I am King Clifford Jefferson, ascendant and descendant of Godfrey the fifth kind of band Jew, son of Pope, ruler of Jerusalem. I am the personification of King Edgar the Peaceful, which we know as the Vicar of Christ. It is May 13th, 2026, which is equivalent to the Berber year 2976. I greet you in the name of my Queen Sister Lisa Galveston from the House of Galveston. I greet you in the name of my Archbishop Belmont from the House of Belmont. I greet you in the name of all the officers and staff. I greet you in the name of you. This is My People, the Truth. Once again, this lesson is called My People, the Truth. All that you seek is right here in this lesson. Please listen. Once again, my people, here is the truth. Okay, all that you've been seeking, all that you ever wanted to know about who you were as a people, without all the bluff, this is the lesson for you to pay attention to. This is a narrower view of a broader view that gives you the best position of truly understanding our story. Okay? So without further ado, let's get started. Like, share, subscribe, donate your free and common soakage to $ Clifford Jefferson L. Once again, Bees was right when he said the true English nationality is in the church. What church? The English church, which is now called the Third Temple English Church of England. And with that, we get started with this marvelous lesson. Okay? The title of this lecture is called My People, the Truth. All that you seek is right here in this lesson. All you got to do is listen. As I always show, is a pictogram or diagram explaining, because we know that picture speaks 1,000 words. When I teach, I like to show examples, the proof, the evidence, or the merits in which we base our claim on. Because really, it's all about, whether we know it or not, two words. And the two words is capacity and interest. Capacity and interest. If you don't have the capacity, you don't have an interest. If you don't have the capacity, you do not have an interest. This interest is in regards to citizenship, the capacity to be a citizen. Okay? In order for you to have the capacity to be a citizen, you must have an interest in that citizenship. Okay? That interest comes in two forms: jus soli and jus sanguinis. Being born on the soil and being descended or your parents by way of what we call blood, jus sanguinis and jus soli. Those are two common law terms that originated from my ancestors, who had the capacity, therefore they do have an interest. Specifically, the 1350 Act, De Notis Ultima Re, it was not originally part of the common law. It was actually a legislative or legal fix. which resulted from a gap in a particular situation that arises from those conflicts in lieu of interest and in the capacity involving citizenship. Okay? Very important. So the 1350 Act, also known as the Notice Ultima Re, was a law passed by a monarch which dealt with the capacity to be a national or an alien. To be a national or an alien, whether you're a national subject or a alien subject, or a national citizen or a alien citizen. Okay? Nonetheless, it deals with whether you're a national or whether you're a foreigner. And being born on the soil or have a connection or interest to the soil by way of blood. Okay? Very important. So the 1350 Act, a common law origin, which was a legislative fix supported by the common law. What common law is that? That is Juan Kimar. All of this stemming from the constitutional federal enactment of the 14th Amendment. This is very important because everything hangs upon the 14th Amendment. Even our capacity and interest, okay, as a people, all right, being identified as a citizen. When we say citizen, we're talking about capacity. When we say interest, we're talking about the relative to being on this land. Okay? So if you don't have the capacity to be a citizen, all right, then you don't have an interest on being on this land. If you don't have a capacity to be the king's subject, then you don't have an interest to being on the king's land. Very important. The origin of land law, the origin of just soil and just sanguineous originates from English common law. If we look at the 14th Amendment, if we look at the 1350 Act, it all dealt with where children or where a child was actually born. Okay? Very important. Whether you were born within the king's dominion or the king's kingdom or the king's empire, or whether you were born within the United States or born within the United States territories, or where you were born abroad. All of these factors comes into play in regards to your interest, which is based upon your capacity, which depends upon some type of law that was passed, namely 14th Amendment. Okay? Very important. So when we look at the origin of the root of the 14th Amendment, we have to go back to the 1350 Act. All right? Very important. Being born inside the king's allegiance, when we say the king's allegiance, meaning what we call, uh, uh, what's a better way of saying it? No, the best way to say it is allegiance. Okay? Allegiance to your king, allegiance to your representatives, allegiance to that authority. Okay? Very important. Authority. The king represents the authority. United States represents the authority. That is a legal capacity. Okay? And whatever interest they claim to have an interest in. Okay? Very important. English subjects have children born abroad. Children cannot inherit land in England. Okay? If you're not an English subject, because that all depends upon what? Your allegiance to the king. Very important. Whether you're born within the king's empire, or whether you're born within the king's kingdom, or whether you're born into the king's overseas possessions, or what we call or outlying territories, or if you are born abroad outside of the king's empire or the king's dominion or the king's kingdom or outside of the king's overseas territories or what we call territories. All right, very important. The 1350 Act of the Noches Ultimarie was actually called a legal fix. It dealt with a problem that originated based upon who would be or who would inherit the birthright. Who would inherit the birthright? Right to be the heirs and to inherit the property. Okay, when we say property, we talking about the land. Okay, in order for you to have an interest in the land, because the interest runs with the land. The capacity doesn't run with the land. The capacity comes from someone else, from somewhere else. Okay, who lawfully gave you this capacity to inherit these lands which are in question? Okay, this is very important. This lesson has everything to do with that. All right. So without further ado, let's get started with this marvelous lesson. I'm gonna go very slow. Now we all are aware of the Supreme Court case that's before uh, uh, the judiciary. All right, which is a case called Trump versus Barbara, a 2026 case. You should all be aware of that. All right, we're gonna really understand how important this case is. All right, very important. In the context of the recent Trump versus Barbara, a 2026 oral arguments, the statute of the 25th of Edward III, a sovereign, a monarch, a king, or whatever else you want to call him, was not the primary focus for the justices because it dealt with a separate legal concept than the one at heart of the current birthright citizenship debate. Okay? The one that the case was dealing with was Jus Solis, not just Sanguinius. Okay, very important. When they passed the 14th Amendment, that was just dealing with us being born on the soil. It wasn't dealing with our blood right to be on the soil. Because just because you're born here does not, in fact, guarantee that you are a citizen. Okay? That is very important for us to understand. Why? Why wasn't this mentioned before the justices? Different legal doctrine, such as the 1350 Act, established just sanguineous citizenship by blood parentage for children born abroad. Okay? So if you were born over not within the United States, okay, or within the King's Dominion, in which this act goes back to, an act passed by a king. If you were abroad, say you were in Spain or you were in France, okay, and you were born there, all right. If your parents were not born within the King's Dominion, then you would not, in fact, be a subject of the king. You would be considered what they call a foreign national, okay? Because your nationality, your political allegiance lies somewhere else, okay? So they mentioned this 1350 Act, De Noches Ultimarie, in the Juan Kimmel Art case, okay? This is very important to understand why the justices didn't take the argument up dealing with just sanguineous by way of what we call blood or parentage, okay? And when they say blood or parentage, they're not talking about your physical parent, okay? They're not talking about that because they said your ancestors, okay? It didn't say your family. It said your ancestors, okay? Ancestors is a much broader term than the word family, okay? Like mother or father. That's like a household or a couple households. When you say ancestors, they talk about generations and generations. And they say ancestors and ancestors. Okay? The different legal doctrine. The 1350 Act established just sanguineous citizenship by blood parentage for children born abroad, meaning not having a permanent domicile. The current case is about jus soli, citizenship by birth on the soil. Okay? Because the 14th Amendment text says that all persons born in the United States is so explicit, the justice focused on the meaning of jurisdiction rather than the ancient rule for those born outside of the country. Okay? So they're looking at this prospectively rather than retrospectively. This is very important. Let's move forward. Settled by the presidents, i.e., case law, i.e., the common law. In the 1898 case, United States versus Wynken Arp, the court already thoroughly analyzed this ancient law called de notis ultima res. Okay, they analyzed it. When we say analyzed it, they looked at the plain language of what it says. Okay, all right, very important. They looked at the plain language of whatever the authority came from. United States versus Wynken Arp is a capacity that's given to the judiciary, not the executive department, not the legislature, but the judiciary. Okay, they decide if the capacity is either ultra-vires or intra-vires. Okay, very important. In lieu of that word capacity, and whatever interest they claim to have an interest in. Okay, and this is dealing with what? Citizenship and land. Okay, very important that you grasp that concept. Okay, what is ultra-vires? Let's look at that. Ultra-vires is a Latin phrase used in law to describe an act that requires legal authority. Okay, but it's done without that. Without it, when we say authority, we talk about capacity. When you say capacity, you're talking about authority. If you don't have the authority, you don't have the capacity. When you don't have the capacity, this is considered ultra-vires. This is what we call out overreach. Okay, it's considered a overreach of authority that you assume to have. So it's a presumed capacity. So ultra-vires is a Latin phrase used in law to describe an act that requires legal authority but is done without it. It's opposite of an act done under proper authority, which we know will come from what? The legislator. Okay? And that's only based upon the Constitution. Okay? The Constitution gives them their capacity and limits their capacity. Any act outside that Constitution will be considered ultra-vires because it's not in the interest of the Constitution. Okay? Very important. Acts that are intra-vires may be equivalent to be termed valid, and those that are ultra-vires are termed invalid. Okay? Very important. Legal issues relating to ultra-vires can arise in various varieties of contexts. Companies and other legal persons sometimes have limited legal capacity to act. An attempt to engage in activities beyond their legal capacity, i.e., their scope, may be ultra-vires. Most countries have restricted the doctrine of ultra-vires in relation to companies by via what? Statutory law, i.e., statutory analysis, which is what we call declaratory injunctive relief. Similarly, statutory and governmental bodies may have limited limits upon the acts and activities which they legally engage in. Subordinate legislation, which is purported passed without the proper legal authority, may be invalid as beyond the power of the authority which issued it. Very, very, very important to listen to the last one. Subordinate legislation, which is purported passed without the proper legal authority and may be invalid and beyond the power of the authority which issued it. Okay? Very important to understand ultravirus and intravirus, okay, in regards to authority, i.e., capacity. Settled by prejudice. In 1898, case United States versus Juan-Camargo, the court already thoroughly analyzed the 1350 Act. So they understood the importance of the Act, which is based upon just sanguineous, but uh, uh, they didn't statutorily or they didn't look at the merits of the case based upon the capacity of just sanguineous. They looked at the case based upon the capacity of just Soleil, being born on the soil. Okay? Very important to understand that. All right? They concluded that it was a special legislative fix for inheritance and did not change the general common law rule that birth on the soil makes one a citizen. Modern justices generally treat that historical debate as settled by Juan Kim Art, meaning that jus soli means one thing and jus sanguinis means another. Okay? Focus on the on the 1866 Act. The Solicitor General and the justices spent their time on the Civil Rights Act of 1866 because it is the American document that allegedly repudiated the old British concept. To the court, the inherent intent of the 14th Amendment framers in 1866 is more legally relevant than the 14th century English statute. I repeat. To the court, the intent of the 14th Amendment framers in 1866 is more legally relevant than the 14th century English statute, i.e., De Notis Ultima Re, that dealing with the blood, okay? The inheritance by those who have the blood, born abroad or born within the territories or born within the territory. Okay, where you want to call it the Kingdom of England, or where you want to call it Great Britain, or where you want to call it now the United States. Okay, or the states. Okay, or the 50 some odd states. It still has the capacity based upon the interest that was here prior to the creation of the capacity of the United States and the states. Two different capacities. Okay? Very important. The Kingdom of England or Great Britain and the United States or the states are two different capacities. Okay? You can't deem yourself or give yourself a capacity that you did not at once have. Okay? In the eyes of the court, that will be considered ultra-virus and overreach. Okay? You can't claim to have the capacity of the sovereign, and the authority that gave you the right to exist in that capacity does not mention anything in the plain language of the statute that you are in fact a sovereign. Okay? Very important. Does this ancient law called De Notis Ultima Re actually apply in modern day secular law? Okay? Does this ancient law actually apply in modern day law, which is called secular law? Okay? Does it apply? Let's see. Technically, the 1350 Act itself does not apply in the United States court, but its legal legacy does. Okay? Very important. It says the 1350 Act, they noted ultimately dealing with just sanguineous and not just soleil, but just sanguineous. Not just being born on the soil, but having the right to the soil because of your blood or your descent by way of your what we call hereditaments or your inheritance or your what we call genealogy. Okay, ethnicity. Very important to understand that. One, foundation for the modern statute. Listen, y'all. The idea that children born abroad to the United States citizens are also citizens is a principle first seen in what? The 1350 Act, and is now handled by what? Modern federal law, specifically Title 8 of the United States Code, Section 1401. Did y'all hear that? I know a lot of you heard it, but did you understand what it just said? The 1350 Act is now called Title 8 United States Code, Section 1401. That's what it just said. This ancient law has now been coded as Title 8 United States Code, Section 1401, which is the law dealing with nationals and aliens. Okay? Very important. Very important you understand that because it's also rooted in what? The 14th Amendment. The 14th Amendment came before United States Code Title 8, Section 1401. Yes, the 14th Amendment is a legislative enactment that now was coded in what you call Title 8 United States Code 1401, both rooted in the 1350 Act by Edward III, dealing with not just Soleil and just sanguineous. They couldn't deal with just sanguineous because they understood that those people were those who had a permanent domicile on the soil even before those who didn't have a permanent domicile came on the scene. We understand that the 14th Amendment are those citizens who had the capacity to be permanently domiciled because their history, based upon the blood, goes all the way back to the 1350 Act, they noticed ultimarie, okay, which is now handled by the United States Code, Title 8, Section 1401, Section A. Those born within the territory, those born within the jurisdiction. You must understand it. Two, used as a contrast. In birthright citizenship cases, the 1350 Act is still used by lawyers to show that citizenship by blood always require a specific law passed by the government. You hear that? What specific law was that? The 14th Amendment. All right? Whereas citizenship by birth on the soil is automatic. Constitutional right that the government cannot easily take away, especially if you're born within the territories or born abroad, because they can prove you are a citizen by way of whatever proof they give you, which is a passport, a visa, or any other thing that they use to identify your interest as a citizen. Okay? All right, not based upon just sanguineous, because that was reserved for the true citizens under the 14th Amendment, which is really not needed. Okay, because it all stems to what they noted ultimarie. Okay, three, historical interpretation. It remains a tool for the originalist scholars to argue whether the United States truly broke away from the English common law or simply adapted it. While the 1350 Act is a fascinating historical route, the Supreme Court in Trump versus Barber is far more concerned with whether the 14th Amendment was intended to create a permanent underclass by denying citizenship to children born abroad on United States soil. Would you like to know which specific archives of the National Archives Guide can help you search for these records for a particular region? No, we do not. Why? Because they got me. The Notre Ultramarine Act is now handled by the modern federal law, specifically Title 8, United States Code, Section 1401. Once again, I repeat, Children Born Abroad Act, going back to the legislative act passed by Edward III, okay, a king of the Plantagenet crown, all right, clearly determined that those children born abroad or any of the territories that were within the English Empire, okay, very important, which is distinguished from the kingdom, all right, were in fact subjects and had a right to inheritance that was left by what? Their ancestors, because they had the capacity to convey that interest and whatever claim they had. Okay? Very important. So when you say De Noche Ultramarine 1350 Act is now modernly called Title 8 United States Code 1401. And for that, you must be a citizen and it must be um, uh, validated not just by the common law, but by statutory law. Okay? Through statutory analysis, we're going to prove that. The ancient English statute De Notis Ultramarine, also known as the Statute of Children Born Abroad Act in 1350, was an early precursor to modern nationality law in the United States. The principles it established regarding the citizenship by descent are now codified under Title 8 United States Code, Section 1401. I repeat. The ancient English statute De Notis Ultramarine, also known as the Statute of Children Born Abroad Act of 1350, was an early precursor to the modern nationality law in the United States. The principles it established regarding citizenship, which is a capacity by descent, which is by blood, are now codified under Title 8 United States Code 1401. Okay? But the Supreme Court wasn't dealing with the codified capacity of citizenship by descent, all right, i.e. they notice ultimately by way of what we call blood, which we deal with parents. Why? Because they were not concerned about that. All right. Like, share, subscribe. Let's see the connection and transition. The 14th Amendment to the United States Constitution is not the same thing as Title 8 United States Code, Section 1401A. It didn't say anything about B, C, D, E, F, G, and H. Didn't. It just said A. All right, let's look at them. Now remember, this is De Notis Ultramarine we're looking at, okay? That's why it says immigration and nationality law. We know national makes you your allegiance political, okay, and not civil, okay? Immigration makes your capacity civil and not political, okay? Because just because you're born here does not give you the capacity to be a citizen. For that, you need the blood, okay? Very important. For that, you need the blood. Nationals and citizens of the United States. Take a look at it. The following shall be nationals and citizens of the United States at birth, based upon three specific categories: being born within the jurisdiction or territories, being born within the states or the United States, being born within the territories of the United States, or being born abroad. Okay? Think about that for a second. Let me get up. I was sitting on the floor. Give me 3 minutes. Thank you for waiting. Appreciate it. I want to give special honors to Archbishop Belmont from the House of Belmont of the Third Covenant Church of England for his continuous effort to keep us grounded on the terrestrial plane as well as the extraterrestrial with his marvelous TikTok lessons he be giving. So big ups to you. Okay, so here's De Nortis Ultima, which is our ancient law, modernly now called Title 8 of the United States Code. All right, very important to understand why I say it like that, because that's not me. That's the language of the United States capacity when they came into existence once the British Crown ceded to them by the way of what we call the Treaty of Paris of 1783, which we're going to talk about, not the Treaty of Paris, but the particular capacity that existed at that time, which was under what we call the British Crown. Okay, very important. So Section A, Section B. I ain't got time to read all the classifications, i.e., capacity. Key word: capacity and interest. Whatever this says, whatever section you fall under, gives you the capacity to have an interest of being what they call a citizen here, being born on the soil. Had nothing to do with blood. The only person that can have the capacity and interest being a citizen here by way of blood is those who fall under what they call Section A. Okay? Section A. All right? Anything else is ultra, can be considered ultravirus. Okay? It could be ultravirus, not intravirus, ultravirus. And ultravirus is usually for corporate entities, okay? Corporations. Not for natural people. They're born with the capacity, so anything they do is not considered ultravirus. That's why when New Jersey amended their constitution in 1947, that was the language of what? The 14th Amendment, okay? That gave us our capacity. We inherited us by way of coming to existence into this secular world. Okay? Very important. So section A, B, C, D, E, F, G, and H. Okay? Those are the only interests that you can have to make a claim that you are in fact a citizen or subject, all right, here in these lands. Okay? Very important. And if it's not based upon A, then it can be considered ultravirus. Okay? Very important to understand that. I'm going real slow for you. So the 14th Amendment to the United States Constitution is not the same thing as Title 8 of the United States Code of 1401A. But Title 8 of the United States Code 8 points. Let me start over. I talk too fast. The 14th Amendment to the United States Constitution is not the same thing as Title 8 of the United States Code Section 1401A. But Title 8 of the United States Code Section 1401A is a federal statute enacted to implement and codify citizenship principles recognized what? Under the 14th Amendment. Did you hear that? So the Title 8 of the United States Code was a codification of the legislative enactment of the 14th Amendment, was a result of not the state's law of New Jersey, that would be their constitution, but the federal amendment of the federal constitution. When you go from one constitution to the next constitution, that changes the capacity and it therefore changes the interest because of the capacity. Okay? Very important. For New Jersey, from 1776 to 1844 was one capacity. From 1844 to 1947 was another capacity. Okay? Before those two, there was a capacity that was here that existed going all the way back to what we call time immemorial. What capacity was that? That was, in fact, the crown of what? England. Not Britain, not Great Britain, not UK, not Ireland, not Wales, but England. All right? I'm going to prove it if you take the time and listen. The relationship works like this. 1. The constitutional foundation, the 14th Amendment. The citizenship clause states that all persons born, okay, or naturalized in the United States and subject to the jurisdiction thereof, are citizens of the United States and of the states wherein they reside. Okay, so you not just have a citizenship on the or capacity on the federal level, but you also have it on the state level. Two different capacities, my brothers and sisters. Okay, but the capacity can be considered ultra virus, okay, upon judiciary scrutiny. Okay, this is very, very, very important because the United States Constitution didn't declare their independence. They verbally, part self, the legislative didn't declare their independence. It was their declaration of July 4th, 1776, which declared their independence. Okay, but they didn't have the capacity to declare an independence. Even their constitution that they created before that on what? July 2nd, 1776. Okay, that's when New Jersey declared created their constitution, July 2nd, 1776. But they spoke on behalf of all the colonies. Okay, which were one capacity. Very important to understand that. They declared their independence on July 2nd. When they created their constitution on July 2nd, 1776. Okay, they didn't declare their independence to July 4th, 1776. Okay, so what capacity was here before you created your Constitution on July 2nd, 1776, which is the capacity that's limited to the capacity that's given by the Constitution. Okay, but then you declare independence 2 days later from what? Great Britain, which was another capacity that was here since 1702 under the authority of who? Queen Anne, which was not the same capacity as a monarch under the capacity as a King of England, because Kings of England and the Kings of Scotland are two different capacities. And lieu of inches in the colonial lands here that was under the jurisdiction of the capacity of the Kings of England, because that was called, in fact, the English Empire, which we'll get into in a second. Okay. This is the supreme constitutional rule of birthright citizenship in the United States. All right. So we have the 14th Amendment that was enacted on the federal level, and we have a code enacted on the federal level. Okay, meaning the same thing. It's a nationality and alien enactment. Okay, or code. 2. Federal statutory codification. Title 8 United States Code in Section 1401 defines who is a national and a citizen of the United States at birth. Did you hear that? At birth. That is Section A. Section 1401 includes several categories, including persons born within the United States, okay, any other United States, and at one time, those states were at one time called colonies, or persons born abroad to United States citizen parents, or certain persons born in territories or possessions of what we call the United States. Okay, very important. Specifically, Title 8 of the United States Code 1401A historically referred to persons born in the United States and subject to the jurisdiction thereof. The exact lettering subsections have changed over time through amendments and reorganization of that said statute. Okay? So, the 14th Amendment constitutional source is a constitutional source. Title 8 of the United States Code 1401 is congressional statutory framework implementing citizenship rules. The Notice Ultimatum is a 1350 Act, which is historical ancestors of citizenship by descent concept later, seen in English common law and eventually American national law. I repeat, the Notice Ultimatum, which is a 1350 Act passed by King Edward III of the Plantagenet Crown, is a historical ancestor of citizenship by descent concept later seen in English common law, i.e. Wynkomer Art, and eventually became American nationality law, i.e. Title 8 United States Code, Section 1401. Okay? Forgive me, I'm getting over a cold. During the April 2026 oral arguments in Trump versus Barber, the Solicitor General D. John Sawyer argued that the citizenship clause of the 14th Amendment and Title 8 of United States Code, Section 1401A, do not grant automatic citizenship to children of undocumented immigrants and temporary visitors. Regarding the statutory language and historical concept like de notis ultima re, his core arguments was as follows. What were they? This is Solicitor General speaking on behalf of Donald Trump. These are Solicitor Generals in the opening statements in the argument hearing, the briefing, based upon their brief. This is what Justice Sawyer argued. Justice Sawyer argued that the phrase subject to jurisdiction thereof in Title 8 of United States Code, Section 1401A, was meant to adopt a narrow, not broad, my brothers and sisters. If they was to do it broad, they would have to do it based upon what I'm telling you today. They're not doing that, okay? They took a narrow review because they know if they had a broader review, they would be telling themselves. So Justice Sawyer argued that the phrase subject to jurisdiction thereof, in Title 8 of the United States Code, Section 1401A, was meant to adopt a narrow historical interpretation rather than a modern one, stating it brings with it the constitutional meaning that does not confer automatic citizenship on the children of undocumented immigrants and temporary visitors. Regarding de notis ultima re, his historical allegiance, Sawyer contended that birthright citizenship required direct and immediate allegiance, stating that citizenship clause was adopted after the Civil War to grant citizenship to who? The newly freed slave. Once again, regarding de notis ultima re, a law passed by a king in the 14th century, and in historical allegiance, Sawyer contended that birthright citizenship required a direct and immediate allegiance, stating that citizenship clause was adopted after the Civil War to grant citizenship to the newly freed slaves. I didn't say it, the Solicitor General said it. And their children whose allegiance to the United States all of a sudden now becomes the United States, but you're talking about the 1350 Act passed by a king. Okay? So it says that, and their children whose allegiance to the United States has been established through the generation of domicile, i.e., permanent domicile. He further affirmed that the test for citizenship should be based on the domicile of parents. So if they say in domicile of parents, they're not talking about just Soleil. They're talking about just sanguineous. They're not just telling us that, okay? They're talking about just sanguineous, by blood or parents, which automatically had to be looked at in the eyes of what we call English parliamentary legislation, de notis ultima re, okay? Very, 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 very important for those who are listening to me today, okay? Specific courtroom quotes. On a modern context, unrestricted birthright citizenship contradicts the practice of overwhelming majority of modern nations. It demeans priceless and profound gift of American citizenship. On migration, 8 billion people are on one plane ride away from having a child who's a United States citizen. 8 billion people who are a plane ride away from having to become United States citizenship based upon the one just saw. not just sanguineous, but but Solicitor General is not dealing with just so. He's talking about blood of the parents, which automatically goes back into what we call Title 8 of the United States Code, Section 1401, Section A, okay, which is based upon the historical rule, they notice Ultra Marie, Children Born Abroad Act, okay? If you're not born within the United States or born within the territories, or if you're not a children born abroad of a parent here in the United States, you are not a citizen. Okay? We must understand how important this is. All right? The English Empire in America, or later called the British Empire in America, refers to the colonial territories claimed and controlled by England and later Great Britain on the American continent. Did it say UK? Did it say Great Britain? Did it say Europe? No, it did not say that. It said the English empire in America. America was the term created by those who colonized, i.e., this landmass, when it was in fact the English Empire. I'm going to prove it. Okay? I am going to prove it if you have the longevity to stay here and listen. Historical context of the title concerning the English Empire in America. All right? Territorial meaning. In the 17th and early 18th century, map makers used the term English Empire to describe England's string of colonies along the Atlantic coast, such as Virginia, New England, and Maryland, as well as territories in the Caribbean and Newfoundland. English versus British. The title English Empire was common until what? The Acts of Union in 1707. Then it became what? The British Empire. And boy, we got a lot to talk about that today, okay? Which joined England and Scotland into the Kingdom of Great Britain. For that, you need to understand the Union of the Crowns going all the way back to who? King James, the sixth king of Scotland, and he didn't become the first king of England until he married Margaret of Tudors, who was the daughter of Henry VII from the House of Tudors, who conquered the Cadet branch, which was the branch of the Plantagenet crown, which was ruled by the kings of England, King Edward the Third, the Second, the First, and on down. Okay? Very important. Imperial ambition. These maps were often more than just geographical tools. They were political statements of what? Territorial claims. Okay? So territorial claims based upon that map, which said that the English Empire was in the continent of North America, lets you know that America, which was an empire, belongs to who? The English. Okay? Alright? Very important because the English, the French, and the Spanish prior to the Spanish colonization or the Spanish conquest, all right, under the Spanish Empire by Queen Isabella, we were all one family. We're all cousins fighting amongst ourselves, which is the reason why we have to understand what the Notre Marie or the 1350 Act passed by Edward III has to do with what we call the War of the Roses. Hold that thought. Sitting on this hard floor. Okay. Now let's see. Imperial ambition. These maps were often, like as I said, not more than just geographical too. They were political statements of territorial claims. For example, Henry Popple's 1733 map is famous for showing expansive British claims that overlap with French and Spanish territories to signal imperial ambition. When we talking about Spanish and French claims, they're talking about now on the continent of Europe, which didn't come into what we call the Gregorian era, the Victorian era, and what we call the Edwardian era, okay? All these descended from what we call the House of Hanover, okay? Prior to that, the history concerning Spain and France was right here on this landmass called North America. They just want to call it New France and New Spain. Bull crap. This was France and Spain here and what they now call North America, because at this time we were all family, going back to the War of the Roses, the 100-Year War, and the Castilian Civil War. Yes, we were all family. One family. Let's continue. I'm going to prove it. Let's bypass this. From De Notis Ultimae 1350 to Title 8 of the United States Code, Section 1401, which was the legal lineage of citizenship across the seas. You hear that? All right? Very, 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 very important for you to comprehend that. All right? A map of New England, New York, New Jersey, Pennsylvania, Maryland, Virginia. Before they were states, before they were colonies, these were called kingdoms. Okay? These were called kingdoms. All right, how we know they were kingdoms? Because they were within the English Empire here in what we call North America. I didn't say that. The map maker said it. What map maker? Robert Morton. Okay, Robert Morton. The Origin de Notices will be 1350, enacted by Edward III to ensure that children born beyond the seas to English parents were natural born subjects, now citizens, capable of inheriting lands and owing allegiance to who? The king. This is very, very, very important because it denotes to your capacity and interest to the land. Okay? What gave you that interest and capacity? That king. Okay? Not the United States, not the colonies, not Great Britain, not the House of Stuarts. The English kings. 2. The principles established citizenship by descent, just sanguineous. Allegiance to the sovereign, not by soil. Rights to travel within the with the subjects, not the territory. Point itself. Rights travel with the subject, not just the territory. So you were inherited with this capacity and a right based upon your allegiance to the king, which is your right to be on the king's land, based upon how the capacity was transferred from time immemorial up to modern day. Okay? We understand that the 1350 Act of Edward III was a legal fix. It was not originally part of the common law, but it was an act passed by what? The legislator. Not the executive, not the judiciary, but what? The legislator. Now it's modernly called Title 8 United States Code, because who passed Title 8? It wasn't the executive department, it wasn't the judiciary, it was what? The legislator. Okay? Today, the principle de notice ultimae lives on, and the United States federal law defining who is a United States national and citizen at birth. Did y'all hear that? All this stems from who? King Edward III, an Anglo-Saxon king, a dark-skinned Anglo-Saxon king, not based upon where he was born, not based upon the color of his skin, but based upon his genealogy. Okay? Very important. His genealogy, as it was in the beginning, shall be in the end. Not the same way it was in the beginning, but how it grew modernly, how it was secularized. This is very important for us to understand that. All right? King Edward III. All right? 1312 to 1377. Defender of the Realm, Lord of Ireland, Duke of Aquitaine, and founder of the legacy Beyond the Seas. Okay? When he say beyond the seas, he's talking about foreigners, not nationals. He's talking about foreigners and their right to be in the king's dominion. Okay? The children of the King of England, in whatsoever part they be born, to be capable of inheritance, based upon the notice ultimatum, which is now modernly called Title 8 of the United States Code, Section 1401A. Not B, do G, do H. Okay? How many of you understand what your king is telling you? If you don't, you will by the end of this lesson. The notice ultimatum, the beginning of portable citizenship. You hear that? The beginning of portable citizenship. All right? This was created to protect you against those who made a claim against citizens, such as those who were foreign nationals. Okay? 1608 is a prime example of a foreign national claiming to be a citizen on the soil that was governed by the kings of England and their nobles, their heirs, okay, i.e. their descendants by way of being of the blood, okay? This was carried over into the Declaration of Independence of those who were not Englishmen, declaring the rights of Englishmen as stated in the case One Kimmel Ark, because it said the founding fathers took the folk right of the English and claimed it as their own. Okay? Very important. If they took it, guess what? Title 8 United States Code, Section 1401 is going to give it back to us. Okay? Because it determines who actually have the proper capacity and interest that runs with this inheritance. Okay? Very, very, very important. But you must know the whole story. No one, I don't care what platform you go to, on YouTube, TikTok, other than Archbishop Belmont's platform, there's no other platform that you can go to. YouTube, Facebook, uh, um, or any other platform that can deliver like I deliver, because it's all about the capacity and interest. They can't give you this because they don't have the capacity and interest running with the land. Okay? So they won't fall under just sanguineous. They only fall under just soil, which is now in question because it can be considered ultra-virus if it doesn't go back to your proper parents. When we say proper parents, we're not talking about our mother and father. We're talking about your ancestors. What ancestors? The Plantagenet kings. I'm going to prove it because it was explained through what we call the War of the Roses. Okay? It was explained. Let's see. The 1350 Act, enacted during the reign of Edward III, this statute allowed children born overseas to English parents to inherit land and to be considered natural-born subjects, and established the early legal framework for just sanguineous right of blood. The modern United States law to date, which is Title 8 of the United States Code, Section 1401, specifically Section 301, which deals with the Immigration and Nationality Act, defines who is a United States national and citizen at birth. Modern provisions. The current federal law handles several categories once governed by those ancient principles, such as birth, let's read them. Birth abroad to United States citizens automatically grant citizenship if at least one parent has resided in the United States prior to the birth, or birth abroad to one United States citizen parent, provided citizenship is if the United States citizen parent meets specific presence requirements in the United States before the birth. Okay? Or unknown parentage. Presumed citizenship for children of unknown parentage found in the United States under the age of 5. Okay? So those are the three categories that you must take into consideration to see if you do have the capacity and the interest of being a citizen slash subject. Why do I say this? While the 1350 Act primarily addressed inheritance and allegiance to the king, its conceptual descendant, Title 8 United States Code, Section 1401, focuses on the modern administrative and constitutional standard for acquiring citizenship outside of the United States territory. Not inside, but outside. Okay? Now let's really get deep. The Statute de Notre Automne, which is 1350 and 1351, and the War of the Roses are linked by the fundamental question of who is legally English enough to inherit the throne. Did you hear that? The Statute de Notre Automne and the War of the Roses are linked by the fundamental question of who is legally English enough to inherit the throne. While the statute was intended to protect the inheritance right of the king's children born abroad during the Hundred-Year Wars, its wording later became a weapon used to challenge the legitimacy of royal lines during the dynastic struggle of the 15th century. Did you hear that? Did you hear that? I don't think y'all heard me. Okay? I don't think y'all heard me. The Notre Automne and War of the Roses occurred at the same time. The Statute de Notre Automne in 1350 passed by Edward III during his reign. This law addressed a practical problem. Many English nobles and the king's own children were being born in France or other parts beyond the seas due to ongoing wars. Okay? Ongoing wars. We know we're talking about the 13th century. When we talk about ongoing wars, we're talking about afterward. Okay? Afterward. When we talk about war, we're talking about the War of the Roses, the 100-Year War, the Castilian Civil War, and all that resulted in what occurred by the Spanish Empire take over our empire. Okay, then became subject to Queen Anne's War. Okay, to inherit the succession of the Spanish Empire. Okay, which automatically led to the problem we have now. Okay, very important. So it passed during the reign of Edward III. This law addressed the practical problem. Many English nobles, which are you, my brothers and sisters, and the king's own children were being born in France as well as Spain or other parts beyond the sea during the ongoing wars. The ruling, it declared that the children of the King of England and whoever parts they be born were capable of inheriting English lands and the crown. The intent to ensure that being born on foreign soil did not strip a royal or noble heir of his English legal right. This is very important. Why? The impact was impacted by what? The War of the Roses. Watch where I go with this. The War of the Roses from 1455 to 1487 were a series of dynastic battles between the House of Lancaster and the House of York. The 1350 statute played a subtle but critical role and the legal paper war that preceded and accompanied the physical battles. Okay? Let's continue. 1. Defining the line of succession. Because both houses claimed descent from Edward III, the statute confirmed that their lineage remained legally valid even if the ancestors had been born in a continent territory like Aquitaine or wherever else. 2. Weaponizing the Englishness. During the conflict, the statute interpretation was debated. Now remember, this statute is in Juan Kimmel Art's case. During the conflict, the statute interpretation was debated. Yorkists supporters often emphasized the need for a king born in the legions of England, sometimes used the spirit of the statute to question Lancaster's heirs who had strong ties to France like Margaret of Anjou and her son. 3. The case of Henry VII. The eventual victor, Henry VII from the House of Tudors, had spent much of his life in exile in Brittany and France. His distractions used the legal concept rooted in De Noctis Ultima to paint him as a foreign alien. Did you hear that? Who had no right to the English throne, forcing him to rely on right of conquest and his marriage to Elizabeth of York to secure his reign. Did you hear that? His marriage to Elizabeth of York to secure his reign because he was in fact a foreign national. Because why? His daughter Margaret of Tudor married who? King James VI. Not the King of England, just the King of Scotland. Yes, Margaret of Tudor, the daughter of Henry VII, who was not by blood, not by way of just St. Greenies, but way of what we call making claim by way of conquest on soil that did not belong to him. This is the reason why when we look at the location of the Kingdom of England, it moved over to what they now call Great Britain, and it moved from the English Empire, which was over here, because Great Britain was nothing more than the territory of the English Empire, because English Empire is bigger than a Kingdom of England. Okay? We must understand that terminology. Analogous concept. Think of it like a modern citizenship law. If a law says anyone born to a citizen abroad is still a citizen, it's a great it's great until two people start fighting over a job that says only citizens can apply. Then they started arguing over whether the spirit of the law applies to someone who spent 20 years living in another country. Okay, so now it becomes personal now because those who are foreigners are taking the jobs of the nationals when they have a right as a national based upon their capacity and interest in the land. Okay, very important. See, this is what you must do. You must give visualization. People need to visualize this. Okay? De Noctis Ultima 1350 in the War of the Roses. 1. First, let me pull this up. This is a map by Robert Morton. Everyone can see that. A map of the English Empire in the continent of America. Once again, a map of the English Empire. It didn't say Great Britain, British Empire. It said the English Empire. We know Alfred the Great unified the kingdoms, okay, which made it an empire. So we know the empire existed goes all back to Alfred the Great, okay. So that's why we know America, now called America, was actually a part of the English Empire that was built by Alfred the Great and his predecessors, okay, which was known as emperors, okay. An emperor rules an empire, and King Edgar the People and Ashton, his predecessor, were called emperors. Totius Augustus Albanius, okay? Emperor of all Albion, okay? Which was another name for what we call England. Very important. But it says here, a map of the English Empire in the continent of America. So if the English Empire is within the continent of America, how in the hell can it be over there in what we call Great Britain? First question you all got to ask yourself, okay? And some of the kingdoms you see here in the empire are New York, New Jersey, New England, Virginia, Maryland, Carolina, Newfoundland, okay? All right? And then we got another map that I'm not even going to go to, all right? Right there. Pull it up. Map by Robert Morton. Let's go back here. I haven't even gotten to the good part yet. Okay. Problem. The 100-Year War. Many English nobles and the king's children were born in France or other parts beyond the sea. Remember, uh, the War of the Roses, not the War of the Roses, the 100-Year War was a result of the throne of the French throne, not the English throne, but the French throne. Okay, and the Castilian Civil War was based upon the Spanish throne. Okay, and the maternal connection between the Spanish and French throne was aligned with the English because the English married into French and Spanish noble houses. Okay, very important to understand that. So, two, the Statute de Notre Ultima, the children of the King of England in whoever parts they be born should be capable of inheritance. And we're not talking about over there on the European continent, because now those people are identified in here in what we call North America as white people, okay, based upon the operation of a color of the skin. All right, we're not playing that game anymore. All right. So, three, the intent to ensure that the being born on foreign soil did not strip a royal or noble heir of their English legal rights. So if you were here in the English colonies and you traveled to New Spain or New France, all right, that birthright would travel anywhere you went, okay, on this landmass within the English Empire, okay, because we know that New France and New Spain was a result of conquest leading all the way back to what we call Henry VIII and Henry VII. Four, impact. And I'm going to show you, not just from this diagram. Impact of the War of the Roses, 1455 to 1487. You had the 100-Year War, right, which was a result of what? The French throne. The French throne, all right? French throne. I ain't got my teeth in, so forgive me. But the French throne with Edward III succession, okay? All right, they already was control of the English throne because it was passed from William the Conqueror, son Stefan, as a result of the marriage of Empress Matilda to Godfrey V, Count of Anjou, son of Fulk, ruler of Jerusalem, the ruler of King of England in France. Okay, and France was ruling Jerusalem at this particular time. All right, so the impact of the War of the Roses was secured after the 100-Year War. All right, and as well as the Castilian Civil War. The statute became a legal tool and weapon during the dynastic struggle between the House of Lancaster and the House of York. Okay, right there. 4A, defining the line of succession. This is when it became a fight over maternal and paternal succession of the crown. Okay, this is where it went from females ruling, went from kings ruling to female ruling. This is the reason why we had Queen Elizabeth, Sophia, Palatine, Elizabeth of Stuart, as well as Queen Anne. All these were Scottish, Protestant, or Anglican queens who either had German or Scottish descent, which we're going to go through in a second. Okay? Very important. This is why this was implemented by Edward III, de Notre Ultima, now denoted as Title 8 United States Code, Section 1401A. It says both houses claim descent from Edward III. The statute confirmed that their lineage remained legally valid even if their ancestors were born in the continental territories like Aquitaine. 4B, weaponizing Englishness. Debate arose over the meaning of born within allegiance of England. York supporters used the spirit of the statute to question Lancaster's heirs with strong ties to France, Margaret of Anjou and her son. 4C, the case of Henry VII. Henry VII, Tudor, spent much of his life in exile in Brittany and France, which we just read. Distractors used legal concepts rooted in De Notre Ultima to call him a foreign alien unfit to rule England. Did you hear that? A foreign alien, okay? A foreign national, okay? So that meant that if we was going by modern day law under Title 8 United States Code 1401, he wouldn't fall under Section A, okay? He would not fall under Section A. 5. Legal argument in play. Supporters view. The law is clear. Birthplace abroad does not remove the right to inherit. You hear that, y'all? Descent from Edward III is valid. The statute protects royal bloodlines wherever they are born. Okay? Wherever they are born versus distractors view as we've seen by Henry VII. The spirit of the law favors those truly rooted in England. Heirs spent too much time abroad, loyalty is questionable. Right to the throne should be earned through English birth and service. 6. The outcome. War of the Roses. Fought not only on the battlefield, but in courts, parliament, and legal arguments. This is the paper trail. All right? You hear that? Paper, what's that? The paper war. Okay? Here was the seventh victory. He won the throne in 1485 at Boswellsfield. To the settlement. Mary Elizabeth of York united the houses. He claimed strengthened by a conquest in marriage. Legacy. The statute remained part of the English law, but its power to define Englishness was forever shaped by what? Politics. Analogous concept. Let's read that. Oops. Analogous concept. Think of it like a modern citizenship law. If a law says anyone born to a citizen abroad is still a citizen, it's great until two people, as they stated earlier, start fighting over jobs, which is in fact the case. Okay, fighting over the goods, the product. Now it's really about to get real interesting, brothers and sisters, if you have the attention span to hold on. Okay, let's see. Let's go here. Let's go here now. Let's take it back to where it started. Let's go back to the Union of the Crowns. Y'all gonna have to pay attention. Give me 1 second. A couple I done drew the outline. Now let's color in the picture. Okay. I done drew the outline. Now let's color in the picture. What they say, a picture speaks 1,000 words. Like, share, subscribe. Okay. This everything that you see in my lesson plan, all right, that we just spoke about, I'm about to clear all up right now. Okay. And I'm gonna use Wikipedia to do it. We know that the English Empire is within the continent of what we call North America. Okay, we know that. We know that. We know that Edward III's De Noctis Ultimaris was an act that encompassed the capacity of the 14th Amendment, now codified in the United States Code. This is Title 8, United States Code 1401, Section 8. Okay, so we as uh, English people, misnomer as dark skinned, black, Negroes, colored, etc. Right? You must understand that that's not your proper capacity. All right? I have to explain that in part two. Okay? I'm gonna have to do that in part two of this lesson. All right? But for now, let's just fill in and understand why you must really take what I'm giving you and understand it, because if you don't, then you don't have an interest in the capacity as being a subject, i.e., a citizen here in these lands. Okay? It's very important you understand that. And they're using the common law, right, as well as legislative fixes that were put in place to justify everything that I'm telling you based upon my capacity as the modern day king, all right, in lieu of the interest that runs with the argument or the claim that we're making, okay, that no one or any other platform can do. I haven't seen one platform other than ours show the capacity and interest that runs with the inheritance, all right, based upon the Noctis Ultimaris, which is now Title 8 United States Code 1401, Section A. Okay? It says the Union of the Crowns was an ascension of King. Matter of fact, let me just do this right quick. Put our focus on him. All right. Let's put our focus on him. The one who wrote your Bible. King James, the Sixth of Scotland. Okay, very important. We don't care about what aberration of color skin he is. We want to look at the capacity and interest for him to do anything that he claimed to do. Okay? We're looking at his capacity and interest. Who gave him his capacity and interest? Okay? To do whatever he is that he did it based upon his claim that affects us moderately, all right, in the present day. All right? Union of the Crowns was the ascension of King James VI of Scotland to the throne of England. We know the throne of England is an office, the capacity, the authority. Okay? So it was the ascension of King James VI of Scotland, the one you see right here, all right, to the throne, not to the throne of Scotland, but to the throne of England and Ireland as King James I on the 24th of March in 1603. and to the consequent formation of the personal union between the Kingdom of England, Scotland, and Ireland. They wasn't unified till 1707. It was just an act, okay, not a legislative act, but a thought, okay. It follows the death of King James's cousin Elizabeth I of England and the last monarch of the Tudor dynasty. Okay? Elizabeth I, the daughter of Henry VIII, the son of Henry VII. Okay? Which was a foreign national, which we just read in my lesson. England, Scotland, and Ireland remained separate states, i.e., colonies, i.e., kingdoms, because we know that the map under Robert Morton said all these states, i.e., colonies, which were kingdoms, are within the English Empire, not the British Empire. That's Johnny come lately. When we talk about the empires, their authority, their capacity, and interest that they have on the land. England, i.e., Scotland, Ireland remained separate states with separate parliaments until the Act of Union of 1707. So whether they were on the same landmass, their interest and capacity on the landmass was different. Okay? Was different. Now that we got this out the way. We're talking about the English Empire, right? Not the Spanish Empire, Scottish Empire, right? Not the British Empire. And we certainly ain't talking about the Spanish Empire or the French Empire because they're already here in North America. And I told you that they were aligned already with the English Empire through marriage, okay? This was brought us to the War of the Roses, the 100-Year War and the War of the Roses, okay? Very important. That's what led to that point. Let's get it. So we know that England had a separate parliament. Scotland and Ireland had separate parliaments. They didn't unify, and the only way they did unify was by a treaty, not by some legislative conceit, what we call, not by some legislative conveyance, all right? Wasn't by some an enactment, all right? It was based upon economic interest, all right? An economic interest, which is what their capacity was based upon, all right? Very important. Let's look at the earliest unification. This is key right here. In August 1503, King James VI of Scotland married Margaret, eldest daughter of Henry VII of England, and the spirit of the new age was celebrated as the poet William Dunbar, the thistle in the rose. The marriage was the outcome of a treaty of perpetual peace concluded the previous year, which in theory ended centuries of war and border raids between the two states. All right, the marriage brought Scotland's Stuarts into England to the line of succession, though no Scottish prince was likely to inherit the English throne. Did you hear that? Did you hear that? The marriage brought Scottish Stuarts into England to the line of succession, though no Scottish prince was likely to inherit the throne. Key. That's key right there. All right? We're talking about King James VI of Scotland. The only way he became King of England was through his marriage to Margaret of Tudor, the daughter of Henry VII, who conquered the Kingdom of England through conquest as a result of the War of the Roses, which was part of the 100-Year War, involving the inheritance of those who had the capacity to inherit the land based upon the act passed by Edward III of the Plantagenets and the Crown, which was the result of what we call the War of the Roses. Very, very, very important that you understand that. Okay? de Noches Ultramarine, the 50 Act. The Noches Ultramarine passed by Edward III, also known as the Statute of Children Born Abroad Act in 1350, was an English statute during the reign of Edward III. It regulated rights of those born overseas. It was an early precursor to British nationality law. Did you hear that? British nationality law didn't come till 1707 because there was no such thing as British, or Britain. All right? Very important we understand that. Dated from 1351 during the early part of what? The 100-Year War. It addressed issues of inheritance by foreign-born children, which was a topical problem. This statute Edward III was invoked over what? 200 times, and it's being invoked again. All right? And two later matters. In the first of those, it did not prove effective since the outcome went in the other direction. But in the second, it was significant. In the debate of succession of Elizabeth I, who succeeded Elizabeth I? King James, who married Margaret of Tudor. Okay? It was thought to be some to be telling against claimants of the House of Stuart. Why? Because they were foreign nationals. Okay, I didn't say it. Queen Anne said it. Okay? In Calvin's case, it was also brought up to argue against those proposed to have an interest in England of Scottish post-deny those born after the Union of the Crown in 1603, which we just talked about. We just left the Union of the Crown, didn't we? How many of y'all gonna stay asleep out there? All right. How many of you are going to stay asleep out there? The text says, the law of the crown in England and always has been such that children of the King of England, in whatever part they be born, in England or elsewhere, be able and ought to bear the inheritance after death of their ancestors, which laws our Lord the King, the prelate, earls, and barons, and other great men, and all commons assembled in this parliament, do approve and affirm forever. These are trustees, brothers and sisters, right there. Okay, so it's very important you understand how important this legislative enactment, which has now been codified, and Title 8 United States Code, Section 1401A. Okay? Very important. 100-Year War. Let's see what time the 100-Year War. Because I said the Noches Ultramarine was passed as a result of what? The 100-Year War. What year was that? Let's look. Hundred-Year War. The Hundred-Year War was a conflict between Kingdom of England and France, and a civil war in France during the late Middle Ages. It emerged from feudal disputes over the Duchess of Aquitaine and was triggered by a claim to the princedom made by Edward III of England. The war grew into a broader military, economic, and political struggle involving factions from across what? Western Europe. Did you hear that? Western Europe. So this was not just an isolated incident. This was affected the whole world. All right? Very important. The Donuts Conditionalibus was a result of the 100-Year War of the heirs who descended down from these kings who were all located all over the world. Okay? Very important to understand that. All right? I'm not saying this right here in Juan Kimmel Art, common law, case law, that right before the Supreme Court. Let's see it. One Camel Ark. We're talking about statutes, not the Constitution, not a legislation, but a statute. It says both in England and the United States, indeed, statutes have been passed at various times, including Title 8 United States Code Section 1401, Section A. All right, that have been passed at various times, enacted that certain issues born abroad of English subjects or of American citizens, you hear that they put it in the same sentence, respectively, should inherit to some extent at least the rights of their parents, ancestors, but those statutes apply only to cases coming within their purport. So how many of you out there that claim to have an interest in capacity of your ancestors, interest in land from England or wherever the hell you come from, raise these claims? And they have never been considered in either country as affecting the citizenship of persons born within its dominions. Okay? Very important you understand that. How many are raised in this purport? You can't raise it because none of y'all know who the hell who Edward the Third is. Okay? Because the first or the earliest statute that was passed in England and the United States, since England, don't believe me, let's go to English overseas possession. Now we just seen a map of the English Empire. Where did it go? I didn't create this map. Look again, y'all. This backs up what Wikipedia say. This is an actual map from a map maker. A map of the English Empire in the continent of America. This is an actual map from 1695 to 1704. Okay? Right there. No disputing that. Okay? Now we go on to English overseas possessions, Wikipedia. And it says English overseas possessions. The English overseas possessions sometimes refer to what? The English Empire. Hold on. Somebody got to stop and ask themselves. How could this be? The Kingdom of England is smaller than the English Empire. Okay? The English overseas possessions, sometimes referred to the English Empire, comprised a variety of overseas territories and colonies that were conquered or otherwise acquired by who? The Kingdom of England before the unification of Great Britain, which is Ireland and Scotland unifying with England. Okay? The possession was already in the English hands. Capacity. It's right here in Wikipedia. Before the Acts of Union of 1707, which joined England with the Kingdom of Scotland and they created what they call the Kingdom of Great Britain. They didn't say the Empire of Great Britain. It said the Kingdom of Great Britain. Why? Because it was just starting out. Formerly, Scots were excluded from the English overseas possession. Why? Because they were foreign nationals. They did not have a right. I didn't say that. Their own queen said it. Let's prove it. But following the 1707, they could participate in the expanding the British Empire. Let's read that one quote again. Matter of fact, the first two, the paragraph below it as well. Watch the light that comes from your king. The English overseas possession, not British, not Scottish, not Ireland, not UK, sometimes referred to the English Empire as the map said, which means that the United States and all the states are in fact an English empire as well as the overseas possessions which are in Europe, Africa, UK, etc. If our people are over there. Because that is a genealogy test first. For that you need blood. Okay? And when I say blood, I'm not talking about physical blood. I'm talking about a legislative fix. De notis ultra Marie. That's what you need. Okay? So the English overseas possessions, sometimes referred as the English Empire, comprised a variety of overseas territories and colonies that were conquered or otherwise acquired by the Kingdom of England. When they say conquered or acquired, then they're talking about to the original forebearers of the Kingdom of England, which was Alfred the Great and his successors. Okay, they're talking about those under the Great Britain, those under France, and those under Scotland who were not in the interest of the English crown. Very important that you understand that. All right. So it goes on to say that they were conquered or otherwise acquired by the Kingdom of England before 1707, when the Acts of Union joined England with the Kingdom of Scotland, which created the Kingdom of Great Britain. Formerly, hear that? Formerly, Scots were excluded. Didn't say included. Excluded from English overseas possessions. So if they were excluded from the English overseas possessions, they were excluded from what? The English Empire. So they did not have a right to any other colonies here in North America. Can anyone get who understands that? Can give me a thumbs up in the chat line. Give me a thumbs up if you understand that much. While I wait for that, is that the first English overseas settlement was what? Ireland, and patterns of rule over subordinated populatory territory developed following the 16th century Tudor conquest. You hear that? There were initial English voyages of exploration during the reign of what? Henry VII, the father of Margaret of Tudor, who married King James. And fertile settlements in Ireland. During the reign of Elizabeth I, there was an unsuccessful attempt at North American colonization. You hear that? There was an unsuccessful attempt by the daughter of Henry VIII, the son of Henry VII, who took over the Kingdom of England. And this is when the location switched from here to there. Okay? It switched. We must understand the game that's being played, because the first successful attempt in North America by by Queen Elizabeth, as it said, right? It just said it was 1558 to 1603. Now watch this. Let's look up the Kingdom of England instead of the possessions or the English Empire. Look at this. I'll pay attention to the detail. You better get over to Archbishop website. He's dropping it. Kingdom of England. The Kingdom of England was a sovereign state in the island of Great Britain and on the islands of on the island of Great Britain from 927, when all the Anglo-Saxon kingdoms were unified under the rule of Ashton, and Ashton styled himself as an emperor. Okay, not a king, but an emperor. All right, which was united by Ashton until what? May 1st, 1707, when it relinquished its sovereignty along with Scotland to form what they call the Kingdom of Great Britain, which would later become what they call the United Kingdom. Okay, very important. Look at the location in 1558 when when Elizabeth I started the first succession here in what they call North America, where it says, look at the location of the Kingdom of England in 1558 to 1707. It's over there now. English overseas possessions in 1700. It's just like it was in the English overseas possessions. All right? The English Empire. It is right here, brothers and sisters, right here. All right? Now we go back to English overseas possessions. It just said. Now we know the English overseas possession, it's called the English Empire. And we got a map saying that it is the English Empire, and all the colonies that King James claimed to come to was a part of the English Empire. Okay? It says here, there were initial English voyages of exploration during the reign of Henry VII of England, where King James got his start from, and further settlement in Ireland. During the reign of Elizabeth I, there were unsuccessful attempts at North American colonization. Not until the succession in 1603 of James VI of Scotland to the throne of England, ruling as James I, was permanent were permanent overseas settlements successfully established in North America. First at Jamestown, Virginia in 1607, West Indies, and then the Plymouth colony of religious dissenters in New England in 1620. All these were in areas already occupied by who? Indigenous populations, and claimed by what? The Spanish Empire, but not settled by it. Did you hear that? That's a mouthful, y'all. That is a mouthful. I can go on for days with that. Come on, y'all. Put the thinking caps on. Let's get back to it. Okay. So back to the Union of the Crown. Okay. So King James of Scotland married Margaret of Tudor, the eldest daughter of Henry VIII, all right, of England. And spirit of the new age was celebrated by the poet William Dunbar, the Thistle in the Road. Excuse me. The marriage was the outcome of the Treaty of Perpetual Peace concluded the previous year, which in theory ended centuries of war and border raids between the two states. The marriage brought Scotland's Stuarts into England to the line of succession, though no Scottish prince was likely to inherit the English throne. So if they couldn't inherit it, they had to what? Steal it. How I know it? Let's see it. This is through what they call the Act of Settlement. Let's look at it. Watch your king. Watch my work. Act of Settlement 1701. Queen Anne is not the queen yet. Okay? Let's get the War of the Roses first. Yeah, War of the Roses. Because 1350 Act had everything to do with that. It's called the Cousins' War. We all cousins fighting amongst ourselves. Okay. The War of the Roses is known at the time in the following centuries as the Civil Wars and also the Cousins' War, were a series of armed confrontations, machination, battles, and campaigns fought for control of what? The English throne. From 1455 to 1487, the conflict were fought between the supporters of the House of Lancaster, whose emblem was a red rose, and the House of York, a white rose. Two rival cadet branches of the Royal House of Plantagenet. The conflict resulted in the end of the Lancasters' what? Male line in 1471, leaving the Tudor family to inherit through the what? Female line. The Lancaster claims to the throne conflict was largely brought to an end upon the union of the two houses through marriage, creating a Tudor dynasty that would subsequently rule all of England. The War of the Roses was the War of the Roses. The War of the Roses was rooted in the English socio-economic troubles caused by the Hundred-Year War with France, as well as the quasi-military bastard feudalism resulting from the powerful duchies created by King Edward III. Very important that we understand why the Notice Ultimatum was passed by the Edward III because of his rise to the French throne when he was already ruling the English throne. Okay? And as a result of the cadet branches, the Yorks and Lancasters conflict with the Cousin War, which is a result of the female line, okay? So the male line, agnatic succession. We must understand this is how King James them got their start, okay? How King James got them start, and it started from what? King James marriage to Margaret of Tudor, okay? King James marriage to Margaret of Tudor. From that, set the plan in action. 104 years of planning. Okay? Through what? An act of security of 17 parts. So, what was it called? Act of Settlement of 1701. Let's go back there. The Act of Settlement is an act of the Parliament of England passed in 1701 that settled the succession. Listen, I'm going slow for y'all. To the English and Irish crown, to Sophia of Andover, in the event that Queen Anne died without issue, and to further reaffirm the exclusion of Catholics and anyone who married a Catholic from succession, along with the requirements for the monarch to be in communion with the Church of England contained in the Bill of Rights of 1689. So the Act of Settlement was from 1701, was an act passed by King William, all right, to ensure that the English throne would pass to Sophia of Andover, the father of King George I, who's not even king yet. Hell, Queen Anne's not even the queen yet. But yet they had made preparations to pass successorship, i.e. the capacity and interest to the throne. which is in office, okay, by way of succession through the female line, as was created through the House of Tudors, which was a result of what we call the War of the Roses. Oh, y'all ain't listening to me, okay? This had the effect of disposing the remaining descendants of Charles I and Charles I other than Anne. Sophia was the next Protestant in line of succession. Born in the house of Whistlebach, if I'm pronouncing right, Sophia was the granddaughter of King James VI and the First of England. He didn't become King of England until he married Margaret of Tudor, the daughter of Henry VII, who conquered the Plantagenet king through undermining as a result of the conflict that was arising as a result of us fighting each other of who would succeed to the succession of the crown. All right? Very, very, very important. All right? It says Sophia was the granddaughter of King James VI, and the first king from his most junior surviving line, with the crown descending only to her non-Catholic heir. Sophia predeceased Anne by 2 months, and her son succeeded to the throne as King George I, starting the Hanoverian dynasty in Great Britain and in Ireland. Remember, they did not unify to the Kingdom of Great Britain till 1707. There were separate parliaments in the Union of the Crown in 1603 by King James, who didn't become a king until he married Margaret of Tudor in 1503. Everyone caught up? Okay. Now I have a problem. What's the problem? Let's look at it. The act of security. Not the act of security, not that. Let's go here. We got a problem right here. New Jersey Provincial Council. His Majesty's Council for the Province of New Jersey was the upper house of New Jersey's legislature under colonial rule until it was replaced by New Jersey Legislative Council under the New Jersey Constitution of 1776. We're talking about capacity and interest. Look at the authority of the crown. The capacity, i.e. authority, is what? Indefinite. Whether we were in Perth Amboy, where I previously was domiciled, which now I'm in Burlington now, presently, okay, where we are permanently domiciled in the capacity as the office which holds the crown, which authority and length of term is what? Indefinite. This authority was usurped by way of New Jersey's Constitution of July 2nd, 1776, which is where they get their capacity to create a legislator, okay? All right, without the Constitution, there will be no legislative branch, and the capacity and authority was here before their Constitution was that of the crown. Okay, the Provincial Council was established in 1702. A year later, upon surrender of the proprietors East Jersey and West Jersey to the right of government to Queen Anne. Anne's government united the two colonies as the province of New Jersey and World Colony, established a new system of government. What government? The Crown's government. You hear that? The body of politics. So Queen Anne was the queen of what? England. Even though she was of Scottish descent, which according to the Notice Ultramarine 1350 Act, they were foreigners. They were foreign nationals. Queen Anne was, in fact, a foreign national. How I know it? How I know? Let's look at it. So after Queen Anne comes to rule, all right, 2 years later, there was an act of security passed by the Parliament of Scotland. Let's look at it. As a result of the Act of Settlement in 1701, which was the Act of Parliament of England, for the succession to pass to Sophia of Hanover, the granddaughter of King James VI of Scotland, who didn't become the King of England until he married Margaret of Tudor from the House of Tudors, which was an illegitimate capacity to be King of England, because they got that capacity through conquest as a result of the what? War of the Roses, who would inherit the English throne, which is an office, a capacity, and an interest that runs with the land based upon a birthright that was passed by a legislative legal fix by Edward III. So the Act of Security of 1704 also referred to an act for security of the kingdom, was a response by who? Parliament of Scotland, not the Parliament of England, but Scotland to the Parliament of England's Act of Settlement in 1701. And we know what the act said. Queen Anne, last surviving child, William Duke of Gloucester, had died in 1700, and both parliaments needed to find a Protestant successor. The English Parliament had settled on English elected Sophia of Hanover, granddaughter of King James VI of Scotland, and assumed to be the first king of England, assumed capacity, without consulting the Scottish Parliament. So, Scottish Parliament passed an Act of Security because the Act of Settlement in 1701 was created without Scottish Parliament consent, which automatically resulted in Parliament of England passing another act called what? The Alien Act of 1705. So the Act of Security was in 1704. The next act passed by the Parliament of England to combat the act of passed in 1704 by the Parliament of Scotland, which is called the Alien Act of 1705. Let's look at it. Alien Act of 1705. Remember, the De Noche Ultimarie was not about foreigners, it's about nationals, okay? 14th Amendment was not about foreigners, it was about nationals. Title 8 United States Code Section 1401A is not about foreigners, it's about nationals. All the other sections after A of Title 40 of Title 8 of 1401, it has to do with immigrants, which are foreign nationals because they are nationals of another country. This must make sense to you for you to understand your own capacity and interest that runs with this land now called America. Okay? It is an empire, y'all. What empire? Our empire. Whether you are of Spanish descent or French descent, nonetheless, you are connected to this family by way of my charter, okay? Which we'll get into part 2. Alien Act of 1705 was an act by who? Queen Anne. Not the one who passed the Act of Settlement of 1701, which was King William. All right, King William passed the Act of Settlement of which Parliament in return passed the Act of Security Act in 1704 because they didn't want to agree to the Settlement Act of 1701. This is why Queen Anne passed the Alien Act of 1705 because they know that if they didn't go along with the plan to elect Sophia Sophia of Palatine, the granddaughter of King James, then the whole plan for King George to succeed to the English throne will be undermined. Okay? Very, very important to understand that. The Alien Act of 1705 was an act of the Parliament of England in February of 1705 as a response to the Parliament of Scotland Act of Security in 1704, which in turn was partially a response to the English Act of 1701, which we just talked about. All right? We just talked about. The act provided that Scottish nationals in England were to be treated as what? Aliens, foreign nationals, and the state held by Scots would be treated as what? Alien property, making inheritance much less certain. Did you hear that? Did you hear that? The act provided that Scottish nationals, that means King James I, King James II, III, IV, Charles I, Charles II, Queen Anne, Sophia, his wife, her mother, which was the daughter of King James VI of Scotland, and those who succeeded them, which was the House of Hanover, the Georgian, Edwardian, Victorian Empire, were all illegitimate because they did not have the proper capacity. It said the act provided that Scottish nationals in England, i.e. the English Empire, okay, or the English kingdom, which is in the English Empire, was treated as an alien foreign national, and the states held by Scots will be treated as alien property, making what an inheritance much less certain. It also included an embargo on the import of Scottish products into England and to what? The English colonies, and about half of Scotland's trade covering goods such as linen, cattle, and coal. There were also embargoes on the export of arms, ammunition, and horses to Scotland so that they could not raise an army to invade what? England. Did y'all hear that? Did y'all hear that? This was in 1705. The Scottish Queen Anne said that they were all foreign nationals because their own members did not agree with the intent of why they created these acts, which was to align King James assumed capacity to be the King of England and transfer that to Great Britain, i.e., to the Act of Settlement of 1701. Y'all must understand what I'm telling you. All right? So we see that the Alien Act of 1705 was declared that all Scottish were foreign nationals. Now let's see what happened now. Acts of Union. Acts of Union of 1707. The Acts of Union of refer to the two Act of Parliament, one by the Parliament of Scotland. They're talking about the Act of Security of 1704 as a result of the Act of Settlement of 1701, which resulted of their member interests to agree to the Act of Settlement of 1701, which brought the capacity that they have now, known as the Kingdom of Great Britain, as a result of the Act of the Treaty of Union in 1707. Following shortly thereafter to an equivalent act by the Parliament of England. They put into effect the International Treaty of Union, agreed on July 22nd in 1706, which politically joined the Kingdom of England and the Kingdom of Scotland into a single political state named what? Great Britain, with Queen Anne as its sovereign. Did you hear that? As its sovereign. Just brought into what we call the succession of the Crown Act in 1707, which is right here. Now, how can they do all this when the Crown of New Jersey is right here in 1702? It has always been here. Succession of the Crown Act of 1707, an Act of Parliament of Great Britain. As of 2025, the Act is still partly enforced in Great Britain. The Act was passed at the time of Parliament was anxious to ensure succession of the Protestant on the death of Queen Anne and replaced the Regency Act of 1705. The Act required the Privy Councillors and other officers in the event that Queen Anne's death to proclaim as the successor the next Protestant in line successor to the throne and made a high treason for any of them to fail to do so. Did you hear that? Did you hear that? So they had to agree to pass the throne to who? Sophia of Palatine. Who is this Sophia of Palatine? Let's look at it. Sophia was an elector of Hanover from 1692 to 1698 as the consort of Prince-elect Ernest Augustus. She was later the heiress presumptive to the throne of England, later Great Britain, following the Acts of Union in Scotland in 1707, in Ireland under the Act of Settlement of 1701, which we talked about, as she was the granddaughter of King James VI and of Scotland and first of England. Because why? He married who? Margaret of Tudor, the daughter of who? Henry VII. Very, very, very important. The mother of Sophia was who? Electress what's good? Elizabeth of Stuart, right here. Mother, Elizabeth of Stuart. Who was she? Let's look at it. Elizabeth of Stuart was Electress of Palatine and briefly Queen of Bohemia, and wife of Frederick V of Palatine. The couple's selection for the crown of the nobles of Bohemia was part of the political religious turmoil that set off a 30-year war. Since her husband's reign in Bohemia lasted over only one winter, she was called the Winter Queen. Who was her father? King James the Sixth of Scotland and the First of England. Right there. There is your proof, my brothers and sisters. There is your proof. All right? So all these, according to the Alien Act of 1705, they are foreign nationals. Okay? They are foreign nationals. The English are not foreign nationals, my brothers and sisters. You must understand this. Let's go back to the lesson plan. Okay. The principles established by the 1350 Statute and dynastic struggles of the War of the Roses provided a legal bedrock for the rights of American colonists. They essentially defined what it meant to be a natural born subject when living far from London. All right. Coming to my closing. One, birthright as a portable right. Birthright as a portable right. The 1350 statute de notice ultimately was the first to legally codify, you hear that? That Englishness was not just about the soil you were born on, but the allegiance you owed to the king. Application to the colonies. When the English settled in America, they rely, and they're not talking about English because the English were those who were permanently domiciled. When you look at the Naturalization Act of those founding fathers, they were not clearly English because they were based upon the aberration of color of skin. We can use case law to back this up, in Way Ahmad Hassan, right here. So they're not talking about the Constitution. It says to summarize the approach which must be followed in deciding whether a particular person applying for citizenship is a white person within the meaning of the Naturalization Act of 1790 as interpreted by the Supreme Court, it is necessary to determine first what particular group or racial division to which the individual actually belongs to. You hear that? And practical effects, proof of this fact is a matter of what? Genealogy. An individual who presents an aberration from the color of skin of the group of which he is a member, such as a light-skinned Chinese or Japanese or a dark-skinned Anglo-Saxon, i.e. dark-skinned English, does not thereby acquire a different status under the Act from other members of his group. Of course, when an individual applying for citizenship has skin of a different color than is usual for the member of the group from which he claims to come, a strong burden of proof then rests upon him to show by the usual methods of proving genealogy that he is in fact a member of that group. After the individual has traced himself to that group, the second question which the court must answer, i.e. the Supreme Court, is whether the member of the group as a whole or white person as Congress understood it in the term of the 1790 when it first enacted the statute. So 1790 had nothing to do with a genealogy test. It only had to do with the aberration of color of skin, whereas now in 2026, the aberration of color of skin in regards to the classification of white people now deem those who are European, Mediterranean, North African descent, and not those from the Caucasus Mountains. Okay? It's very important to understand that. What other case law we got? We got another case law. United States versus Sing Tuk Do. Sing Tuk or Do. It says here, must an American citizen seeking to return to his own native land be compelled to bring with him two witnesses to prove the place of his birth, or else be denied his right to return and all opportunities of establishing his citizenship in the courts of his country? No such rule is enforced against an American citizen of Anglo-Saxon descent if this be a claim as a governed by laws and not of men. I do not think it should be enforced against an American citizen of Chinese descent. You hear that? So Anglo-Saxon, i.e. the new term English, are the true American citizens based upon a genealogy test, which goes into what we call Title 8 United States Code 1401, Section A, in lieu of the passing of the 14th Amendment, which are both federal legislation and codes which mimic the historical legislative law that was passed by King Edward III, known as the Noctis Ultima. All right? Very, 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 very important that you understand that in my closing. Okay. The rights of Englishmen. This became major talking point leading up to the American Revolution. Figures like Samuel Adams argued that since the 1350 statute protected the rights of those born beyond the sea, the British Parliament had no right to treat colonists as second-class citizens or foreign subjects. Yes, they did, because you are not those persons that had the capacity going way back to the 1350 Naturalization Act, because Wynne Kim Art clearly said that y'all took it. How I know it? Let's go to Wynne Kim Art. Both in England and the United States, indeed, statutes have been passed at various times enacted that certain issues born abroad of English subjects of or American citizens, which Imre Ahmad Hassan and United States versus Sing Du or Do disqualified, all right, clearly points that they are protected by the earliest statute ever passed. And what statute was that? A statute passed by Edward III, okay, in 1343 and in 1350. Right here. Right here. Brothers and sisters, you see that. You see that. This is page 26 of the actual case law. All right, go to page 169, U.Ed 669, and you'll find that language right there. Now let's find out how they stole it. Page 78. To what nation a person belongs is by law of nations closely dependent upon what? Descent. That means by blood or parentage, not because you're born on the soil. This is Juan Kim Ark. It is almost a universal rule that citizenship of the parents determines it. That the father, where children are lawful, and where they are bastards, that of the mother. So when you go back to the War of the Roses, moving it from male descent to female descent, that's when we became bastards. Okay, I'm sorry to say it, but that is in fact the case. Okay, what is called partout sequitur via trim. The status of the mother, partout sequitur via trim. All right, that the father where children are lawful and where they are bastards, that of the mother, without regard to that place of birth, and they must necessarily be recognized as the correct canon, since nationality is in the essence dependent upon what? Descent. The framers of the Constitution were familiar with the distinction between Roman law and feudal law, between obligations based on territoriality and those based on the personal and indivisible character of origin, and there is nothing to show that in the matter of nationality, they intended to adhere to the principles derived from the regal government, which they had just assisted in what? Overthrowing. Okay? The Supreme Court ain't going to talk about this. Manifestly. When the sovereignty of the crown was thrown off, an independent government established every rule of the common law, and every statute of England obtained in the colonies in derogation of the principle on which the new government was founded was abrogated. All right? Was abrogated. The states, for all national purposes, embraced in the Constitution, became one under the same sovereign authority and governed by the same laws, but they retained their jurisdiction over all persons and things within their territorial limits, except which was surrendered to the general government or restrained by the Constitution. And protection to life, liberty, and property rested primarily with them. So far as the just commune or folk right related to the rights of persons was concerned, the colonies regarded it as what? Their birthright, and adopted such parts as it was they found it applicable to their condition. You hear that, brothers and sisters? They stole our capacity and interest in regard to what was promised to us by our ancestors. Okay? It's right here in the common law. It's right here in the statute. Okay? Let's close out. We're going to start back here in part 2. Let's close out right here. So the Act of Settlement of 1701, which was ruled in the Treaty of Union of 1707, which was to pass the throne to the Scottish kings. Okay, when the Alien Act of 1705 passed by Queen Anne just said they were what? Aliens, foreign nationals. It said they were in fact foreign nationals. Let me get rid of this. They said they were foreign nationals. It said that the act of settlement was a passage to Sophia of Hanover. Sophia of Hanover was the daughter of who? Elizabeth of Stuart, who was the daughter of who? King James VI of Scotland. Sophia of Hanover was the father of who? King George the First. Okay? King George the First, who succeeded Queen Anne. All right? Very important to understand that. So, in closing, remember what it said. The Act provided that Scottish nationals in England were to be treated as alien foreign nationals, and the estates held by Scots would be treated as alien property, making inheritance much less certain. It also included embargo and imports of Scottish products into England or the English colonies, i.e., the English Empire, my brothers and sisters. The English Empire, and we can prove it was definitely here because it was called what? His Majesty Council. Where's that at? Where is that at? 1 second. I just want to make sure I covered everything. Yeah, right here. Okay. So as you can see, if Queen Anne passed the act in 1705 called the Alien Act, which is modernly now called the uh, Nationality and Alien Act, okay, Title 8 United States Code 1401, Section A, in these other sections, then that lets you know that Queen Anne, all the Scottish queen before him, and all those who succeeded her, all right, are in fact foreign nationals, okay? They are foreign nationals and don't have the right to be on the soil. Okay? We'll continue on with this lesson in part 2. And I hope you all understand how important it is to understand the capacity and authority that people claim to have and look at the interest that they claim uh, interest of. Okay? The interest is to inherit the land because you are in fact a subject of the king in lieu of the allegiance to the king, whereas the foreigners did not adopt. So guess what? They adopted something else. And if you don't remember, then you will be put in that classification or capacity as well. So with that, I'm gonna greet you as I always greeted you in our noble house, the house of the plantation. And with that, peace.